Secondo me io posso fare così. Se io faccio qui, diventa
così, però questo rimane sempre qui.
Vedremo.
No, però scusa, e se no per togliere almeno queste qui sotto sulla visualizzazione.
Est-ce que le mode présentateur è solamente un po' piccolo. Per esempio, se faccio questo,
cioè, quello è sì. Come fai? Non lo vedi?
Ma dai, lo proviamo lo stesso.
So come
no, infatti il problema è questo.
Allora, no, vabbè, ok, gli studenti sì, ma lo deve vedere Philip bene. Allora, puoi provare? Ecco, prova a cliccare qui sopra. Partecipare, questo qui.
Ah, sì.
Eccolo. Questo, no, e che poi lo chiudi? Ok. No, niente, sempre così. Non c'è niente da fare.
E se io toglio la camera?
Se tu togli la camera, prova.
No.
No, che va lì in basso a destra.
Non è una catastrofe.
Secondo me è la visualizzazione delle slide che...
Alberto?
Anna, ciao, ci
Ciao.
senti?
Buongiorno.
Sì, vi sento. Prova con i 3 puntini sotto le slide.
3 puntini sotto le slide lì.
Okay.
E poi?
Masquer le mode présentateur?
Prova con il mascher.
Masquer. Brava. Meglio, molto meglio.
Molto
meglio.
Ok. Non le vedi tutte, però almeno...
No, ma così posso leggere almeno.
Ok.
Ok, brava.
Bene, ottimo Anna del suggerimento.
Niente.
Adesso... No, ok, allora dico 2 parole da qui, già che ci siamo. Ok, hello. Can you hear me? Is there anybody present now?
Yes.
Okay, yes, fine. Okay, thank you very much for being here this afternoon. As I told you in the last class, we have the honor and the privilege to have with us our distinguished colleague, who is Professor Philippe Dorsmond. I am very grateful to him to having accepted our invitation. So thank you very much, Philippe, to be here with us not only this afternoon, but also for 3 days. So thank you very much. I give to him immediately the floor. I change my PC, my position, so Philip could be comfortable in this area without any disturbance. So I give him the floor, and he will tell you how he intends to manage this presentation and all this mini course composed by 4 lessons. So he will give you an explanation, a brief outlook about what he intends to deal with in the next lesson. So thanks again, Philip, and the floor is yours. I move into the other room. Okay.
Thank you, Alberto. Thank you very much. So I'm sorry we are not able to meet in a genuine way, but we will try to teach in a more blended way. Personally, I prefer blended whiskey, but blended teaching is also an option. Now, I was invited to talk about a very specific subject entitled EU collective labor law, so collective labor law of the European Union. And the question is, what could that be? How to define collective labor law of the European Union? Now, the word or the expression collective labor law obviously comes from another experience, stems from other legal orders, national legal orders of the European Union. And we could first wonder what it means in a context of a national legal order. And the word which pops up is then obviously industrial relations. Collective labor law is about what the British call industrial relations. It is about collective relations, employment relations, as opposed to the individual employment relation. The individual employment relation is easy to understand. It confronts an employer with a worker. And the idea is, of course, that in collective labor law, we are dealing with organized employees in relation with or their employer at the company level, or with employers' organizations when we are dealing with issues at branch level or at even inter-occupational, intersectoral level. So in an ideal world, collective labor law is an issue which pops up at various levels, okay? In some countries, of course, which are very decentralized, with a decentralized system, you only have the company level. And another way to approach collective labor law, and this is a typically Italian way to do it, in my view, dating back to Gino Giugni, and also dating back to the fact that in Italy we have a very modern constitution where human rights are at the heart of the constitution. In fact, the first provision of the Italian constitution is Italia è una repubblica fondata sul lavoro. Italy is a republic based upon workers. In this approach, of course, collective labor law is about three fundamental, very fundamental rights, human rights. And which are these? They are the freedom of association, which I sometimes call the right to organize, which is a more specific approach to it, similar to what the French call liberté syndicale, libertà sindacale, the right to organize, and obviously the right to collective bargaining. And if you would go, for example, to the Declaration of Fundamental Rights and Principles at Work from the ILO, dating back to 1998, you can see that the freedom of association and the right to collective bargaining are mentioned prior to all the other 4 and now 5 rights. And then we have, we should never forget about this, the right to take collective action, among which we can find also the right to strike. But can say as a lawyer, if you don't have the guarantee of these 3 fundamental rights, it's very difficult to imagine a legal system of industrial relations, okay? You can imagine industrial relations in a sphere of illegality, but you cannot imagine industrial relations which are recognized, I would say, recognized by the state as a legal order. Now, we all know that collective labor law, no, so please come in and don't mind being late. Collective labor law generates rules. This is another specific feature of collective labor law, and they are autonomous rules. They spring from what we call collective autonomy, autonomia collettiva, as opposed to individual autonomy generating individual contracts. And this is also linked to an idea of subsidiarity. Sometimes it's better that organized employees and an employer or organized employers define the laws applicable to them. That is in essence what autonomia is about. It is the freedom to be governed by the rules you make yourself. Now, collective labor law also ensures another phenomena, which is called worker involvement in EU directives. It's not the idea that workers' representatives make rules, conclude agreements, but that they have some impact, that they can exercise some influence on a decision, which remains to be a unilateral decision, hoping that their interests will be taken into account. And in fact, not necessarily in law, but in fact, of course, collective labor law, industrial relations, in an ideal world tend to pacify, relations between employers and workers. There's always the hope that by making collective agreements and by involving workers, there is some social peace or a temporary truce, and that no recourse to strike, for example, or other collective actions will occur. That is the way in which collective labor law, diritto sindacale at the level of member state is usually understood. Although I should add that there is no common understanding of what collective labor law is, because it can be very different from one country to another. It's perhaps even much more divergent than the individual employment contract, which in essence is, of course, the same in many countries. Yes. Now, I continue. I would like to add a little flavor of Italian legal theory at this moment by making a reference to a famous theoretician of law, public lawyer, Santi Romano. Santi Romano was an Italian scholar and also a judge, who produced a book in, I think, 1918, called Ordinamento Giuridico, the legal order. And this is a confusing title because the book is not really about the legal order. It is about relations between legal orders. It is about the idea that the state is not the sole legal order, that indeed also other groups in society can produce rules. And for Romano, the law is the organization. That is the first structure, the group. That's the first definition of law. And Romano describes how a state as another legal order can recognize these precepts, these rules stemming from other groups in society, other structures, other organizations, or can refuse to recognize them. And when it recognizes them, there are always some strings attached. The state says, okay, your rules are relevant. That is the word which he uses, rilevanza, but under certain conditions. And by doing so, obviously, Romano also indicates that the state, to some extent, controls and is nudging, is trying to influence what is happening. So if we are dealing with collective labor law at EU level, we are interested in the interaction, of course, in the interaction possibly between industrial relations at EU level and the way in which EU law recognize them or not. Now, this brings me to the question, can we just apply this notion, collective labor law, to this part, to this fragment of EU labor law, which is called EU collective labor law? And how should we understand that? Now, I'm doing something wrong here, but don't worry, I will get there. Okay. The idea of the course is that EU law, I'm not saying labor law, I'm just saying EU law affects industrial relations. And it will affect industrial relations at various levels, because this is a characteristic of industrial relations, that they take place at various levels. It will possibly generate a new stratum, a new level of industrial relations at the EU, at the level of the European Union, a kind of level which no state can regulate. It can also affect a level of industrial relation which is not at the level of the EU, but at a transnational level. This means a level including at least 2 states, but not necessarily the entire European Union. An example would be this idea of the European Works Council, which is enshrined in the directive, which can, under certain circumstances, force a multinational enterprise, an enterprise or a group of undertakings at a community level involving at least 2 states, to have a European Works Council, okay, covering all the employees of the firm. But the EU law also affects the industrial relations which solely take place within the boundaries of one nation state. Because EU law is also about harmonization. It is about what we sometimes call positive integration, okay? Trying to create a level playing field in the field of labor law. But sometimes, and this is also an issue in EU labor law, we have to deal with negative integration. We have to deal with the fact that EU law, especially economic law, is being mobilized in order to downgrade, to reduce, okay, a level of protection generated by labor law of a member state or a number of member states. EU law has been mobilized in order to prohibit some strikes, some collective actions, which were perfectly legitimate under the law of the nation state where they place. So it's a complex notion, EU collective labor law, that we are going to speak about. Now, I want to talk you in my attempt to understand what this course is about, EU collective labor law. I want to talk to you about the remarkable person which I had the chance to meet in my life, who passed away already, and that is Brian Bricusse. Brian Bercussen, was the first professor to be appointed in the European University of Florence on a chair dealing with EU labor law. So his arrival in Florence marks the emergence of EU labor law as a discipline, as an academic discipline. And when he arrived, he was trying to do what I'm doing now. He was trying to understand what EU labor law is, just as I am trying to understand what EU collective labor law was. And in one of his many contributions, okay, which were published in this book, In Memoriam, he talks about the understanding and the conception of EU labor law. And what is interesting is the way in which Bercussen tried to understand it. He was teaching with his students in Florence, and he asked them to study the table of books already existing on EU labor law. And he challenged them to compare that structure of those books, of those manuals, with labor law as they knew it from their national experience. And we could do something similar. We only have one problem. There are no books, there's one exception. There are no books dealing with collective labor law at EU level. There are no manuals, there's only one. Whereas in Italy, for example, there are really loads and loads of books on Italian collective labor law, diritto sindacale. But what you can do is, of course, to see whether these manuals of EU labor law in general, the broader perspective, deal with issues which are traditionally dealt with in those books on national labor law, and to see whether we are talking about the same thing, whether things are missing, and so on. And I could start with a number of recent books to see whether these books actually deal with classical issues of collective labor law. And there is the book of Jaspers called European Labor Law, and indeed 80 pages of more or less 400 pages are dealing with subjects, okay, which traditionally are dealt with in books on collective labor law. Issues like bargaining, restructuring of enterprises, and more specifically collective rights of workers, workers' participation. But what Jaspers didn't do was to unite all these subjects under one title, collective labor. In this respect, the book of Carinci and Pizzoferrato, the manual, is more interesting because all the issues of collective labor law are indeed treated in one chapter. One chapter. Chapter 23, it's a chapter of 35 pages. Now, what is apparent, okay, from these first two examples is that the part dedicated to collective labor law subjects is more or less inferior, okay, is much more reduced, much more small than you would see in an average handbook on Italian labor law, French labor law, dealing with individual and collective labor law. That would be the normal division of labor law. Okay, we can take it further. We could look at the famous book of Barnard, Catherine Barnard, who produced many books. She apparently dedicates some pages in well, like 150, and she distinguishes restructuring and collective labor law. Though structuring is about information consultation, could also have been integrated into collective labor law. We see more or less the same approach in another book of Riesen-Huber. So we can conclude that there is much less attention in these classical handbooks on EU labor law to collective labor law than in ordinary national handbooks, and that these books also are not structured according to the very old, bifurcation, dichotomy between individual and collective labor law. And then we have this one book, the only book I know, which is dedicated exclusively to EU collective labor law. It's a recent book published by my colleagues Beryl ter Haar, who now teaches in Groningen, in the Netherlands, and in Warsaw, and by a Hungarian colleague Attila Kun. And I think the image is interesting. I tend to study history of art, so I'm captivated by, obviously, images. And you see these little creatures, and they are working together. They are known for their work ethics and for their collaboration and solidarity. But they have a big job ahead, and they move very, very slowly. And I think this is, in a way, an important message. The path, the rhythm of the development of collective labor law, not just as a discipline, but as a branch of law, is slow. So it's not an issue of revolutions, it's an issue of slow evolutions. Okay. And how do they divide the subject matter? Well, astonishingly, they make a distinction between social dialogue and collective bargaining. And social dialogue is indeed about that stratum in their book at European level. And collective bargaining is about the impact of EU law on the collective bargaining taking place at national level. So you have this very interesting approach. EU collective labor law adds a stratum, but it also affects, and in this case negatively, what is happening within the boundaries of the nation state. It's an interesting book which I could recommend, but it's sometimes confusing because it's not just a pure manual. You have very analytical, descriptive chapters, but you also have conceptual chapters. So there's a kind of a confusion between two genres, between two types of book within the same title. Now, we could wonder for what reason EU collective labor law took so much time to be developed and took so much time in order to be recognized as a discipline. I mean, in Italy, everyone would agree that diritto sindacale is a discipline, and courses would be taught in universities about certainly diritto sindacale, collective labor law. We are not yet there in the field of EU collective labor law. Well, the first thing you should understand is that EU law can only develop insofar as the EU has received competencies to deal with it. EU only has the competence which are exclusively attributed to it. And here we have two problems. We have the problems that few competences have actually been attributed in this field to the EU, and moreover, there is a formal exclusion. There is a formal exclusion of a number of issues which are at the heart of EU collective labor law, like the right to organize, the prerequisite itself, called freedom of association in the provision, or the issue of strikes and lockouts, and even pay. And pay, in a way, is at the heart of collective labor law, because collective agreements in Germany are called Tarifverträge. They are called agreements about wages. And wages, minimum wages, are, I would say, primarily set by means of collective agreements. There is, of course, a possibility to regulate on information and consultation. It's very timid type of worker involvement, allowing workers to influence managerial decisions because they are informed of them before they are adopted, and they have the right to give an opinion upon them. And this field, which has been very developed, can be regulated by means of a qualified majority. What cannot be regulated, what needs to be regulated with unanimity, okay, unanimity, not qualified majority, are fields such as representation and the collective defense of the interests of workers, and also co-determination instead of mere consultation. Now, it's very interesting that the treaty makes this distinction between information and consultation on the one hand and the issue of representation on the other hand, because you cannot distinguish, well, you can distinguish these two concepts, but you cannot separate them. I give an example. I already mentioned a directive on the European Works Council, which is about information consultation within multinational undertakings, groups of undertakings, fines. It has been adopted with qualified majority, but it also creates two actors in the field of representation, which did not really exist. First, a special negotiating body, which will negotiate with the controlling undertaking the agreement leading to a European Works Council, and then secondly, of course, the European Works Council itself. So one might have also argued that this directive needed to be adopted with unanimity. At least the distinction between representation and information and consultation is blurry. Now, I already told you that EU collective labor law, that collective labor law at least, presupposes a recognition of three fundamental rights: freedom of association, right to strike, right to collective bargaining. And here we have a problem. We have a problem because it took until 2009 before the Charter of Fundamental Rights of the European Union came into force and recognized these rights, benefit of the European citizens. I could also mention as a reason why in the real life, in the irrespective of the recognition by the EU law and the EU legal order, few things have happened. The reason is that there is no capability of the European Trade Union Confederation to have recourse to strike, irrespective of the question whether it would be legitimate, which I think it would. The European Trade Union Confederation is not capable of organizing such a pan-European strike. So it has to find other means to influence their other social partner, as we call it, as at least the treaty calls it, the Business Europe Employers Association. We have also seen over the past years, especially, that the EU Commission becomes very reluctant to recognize these precepts of the European social dialogue, to recognize these rules created by the European social partners, and refuses to implement them into EU law, although they made a joint request to the European Commission. We see some reluctance, okay, of the EU Commission to harmonize collective labor law at national level, with the exception of the issue of worker involvement, perhaps. And we see that the Court of Justice is much engaged in negative integration, tries to reduce the level of collective labor law at national level, existing in the national member states, and prohibiting strikes, which are, for example, perfectly legal, or trying to disrupt collective agreements which have been concluded. Now, we see something of this reluctance in the treaty itself, the Treaty on the Functioning of the European Union, because in Article 152, the Union is asked to take into account the diversity of national systems. This leaves some scope, obviously, to harmonization, but this harmonization cannot destroy, of course, the diversity of national systems. And I already mentioned Article 153.5, which is about all these very important subjects which are excluded from the EU competence. And because they are excluded in a very specific way in the title on social policy, it's clear, at least from the point of view of Advocate General Mengozzi, that you cannot just use other provisions in the treaty to tackle, to regulate these issues. I spoke about Santi Romano, remember, who wrote this wonderful book. This is the second edition, Ordinamento Giuridico, which unfortunately has not been translated into English. But we have a nice PhD written in English by an Italian scholar, Andrea Iossa, who tries to explain in proper English the theory of Ordinamento Giuridico, which also influenced Gino Giugni to make a theory about collective autonomy. But what Santi Romano learns us is that the state is not the primary legal order, and that other groups in society actually constitute legal orders, have an original autonomy recognized or not by the state. And when we read in one article, 153.3, which I will explain later, that the state is entrusting management and labor to do something, to regulate, this is still a vision which is completely at odds with the understanding of Ordinamento Giuridico, with Santi Romano, because in the view of Santi Romano, this is not a top-down movement, this is more a bottom-up movement. Collective labor law, if we follow Gino Giugni's interpretation of Santi Romano, is about the fact that the state recognizes the dynamics and the legislative processes, the normative processes which are conducted at the level of the social partners in what was called then l'ordinamento intersindacale. But in the treaty, we see a very old-fashioned approach, which is perfectly, perfectly top-down. Now, this is a general introduction. It's a reflection with all its hesitations about what this course is about. And I'm going to do something which is very traditional during the next hours. I will try to structure the subject matter of collective labor law, EU collective labor law, as it would be done probably in the handbook of diritto sindacale, in the handbook of collective labor law, focusing on these three major fundamental rights underlying collective labor law. And that is, of course, right to organize, that is freedom of association, right to collective bargaining, and the right to strike. And this is peculiar because if you look to handbooks of EU labor law, they primarily deal with another right, which is traditionally considered to be less fundamental, right to information and consultation, which is not part of this classical triad, this classical trio, but which is the field where, with qualified majority, the EU as a legislator has harmonized most. I will not follow this easy path. I will focus on what are the most essential fundamental rights in traditional national collective labor law to see whether they are dealt with in EU labor law as I try to understand it. And therefore I start with the right to organize. I will then tomorrow jump to collective bargaining, the right to collective bargaining. And I will, of course, finish with, this is the grand finale, with strikes, the right to strike. Now, when today I will deal with freedom of association, right to organize, I will have to ask myself, are we there already? Is there such a right to organize? Is it recognized in EU law as a fundamental principle? And when was it recognized? But also, in primary law is the law which you can find in the treaties, you know, Treaty on the Functioning of the European Union, the Treaty on European Union, and also, because it has the status of primary law, the Charter of Fundamental Rights of the European Union. But then there is, of course, what we call secondary EU law, that this is the statutory EU law, which is fleshed out in directives, regulations, okay? I will see whether this secondary EU law has in fact restricted the right to organize, the freedom of association, although technically speaking, the EU has no competence. That is at least what Article 153.5 seems to tell us. And I must admit that secondary EU law has in fact restricted to some extent the freedom of association. I do not deplore this because there is no such thing as absolute freedoms. Well, there are some freedoms which are absolute, but usually they are not absolute. And freedom of association is not absolute. And sometimes, and this has happened, it can be restricted for very legitimate and very social purposes. For example, to combat discrimination. And I also will address, especially this part of the course, an issue which is hardly analyzed in EU labor law and in EU collective labor law. That is the law which is applicable to the EU as an organization. Usually we study EU labor law as law which is being applied by the EU institutions to member states. But we should never forget that the EU is also an employer. And that therefore there must be law applicable to this very specific employment relation. And in this respect, we can wonder, do EU civil servants have a right to organize? And I will then also immediately talk about the issue whether they have a right to collective bargaining, whether they have a right to strike. Okay. Now, since it is 4 o'clock and since I have now more or less nicely introduced the subject, I could propose we have a little break, but I can also take, you never know, some questions, if there are questions at all about this general introduction. You can take the floor or you can write them in the conversation. Last remark in the conversation was, ciao, sorry for being late, but this is not a question. If not, I propose a little break of, well, let's say until 16.10. 16.10, 10 past 4. And then I will continue and I will dig into the right to organize, the freedom of association. Va bene? Okay. See you at 10 past 4. Okay, so I did not get any questions for the time being. So I suggest I continue with the first big issue, the right to organize. And I would like to say that, of course, the issue here is that it took some time before the right to organize was really recognized as a general principle of EU law. The first references to freedom of association were stemming from the Maastricht Treaty. So this is more or less 1992, 1993. To say that the EU was not competent, okay, to deal with it. And that does not amount to recognition of the freedom of association as a general principle. Even if they would have said that there was competence, this is not enough to conclude that there is a recognition of the principle. And then it took indeed until the Charter of Fundamental Rights of the European Union, before Article 12 was adopted, so it entered into force in 2009. And this article mirrors, is very similar to Article 11 of the European Convention of Human Rights, because it unites in one and the same paragraph the right to the freedom of peaceful assembly and a generic notion of freedom of association, which is then followed by a more specific recognition of the right to form and join trade unions, what I call the right to organize. Now, where in the European Convention on Human Rights, in fact, the trade unions, by the way, not the employers' associations, but the trade unions are the only association to be mentioned specifically. In this Article 12, some room is also created for the recognition of political parties. So you could say that the trade union loses to some extent its unique status as the only association being mentioned. Now, I should say that prior to this recognition in primary EU law, we have some jurisprudence of the Court of Justice of the European Union. And sometimes the Court of Justice, in a way, acts as a constitutional court, producing general principles of EU law. And the funny thing was that we could mention two cases where the freedom of association, the right to organize, was being mentioned and recognized, but not in favor of workers, okay, but in favor of the employer. A formal lip service was paid to the freedom of association of an employer. And this happened in a strange case, which is the Bosman case, which is actually about football. Bosman was a football player. I'm not a tifoso. I don't follow it very much. But the point was that once upon a time, it was impossible for a football player to move to another club, a football club, without the football club, the new football club, having to pay a very high transfer price to the previous football club. Now, to cut the story short, you understand that this situation amounts to obstacles to the free movement of workers, because a football player is a worker, but that attacking, okay, this obstacle runs counter rules which have been created by these football clubs and the federation of football clubs to which they are affiliated, and rules which are bounding also upon these football players themselves, because they are not just employees of the club, they are also members of the club. So a conflict, to some extent, arose between freedom of association of these football clubs having an autonomy to produce their rules on the one hand, and free movement on the other hand. And although this conflict was formally recognized, the European Court did not really try to balance, but gave just primacy to the principle of free movement. And then we have another case, that is the Verhoef case. The Verhoef case is very complicated. It's about transfer of undertaking, when indeed a transferee takes over, okay, a company of a transferor. And we know that according to a EU directive of 1977, that the workers, okay, are in such a scenario of legal transfer, transferred from the transferor to the transferee, but they maintain their jobs, and they also maintain their job working conditions, including conditions which are enshrined in collective agreements which are applicable to the transferor, to the old company. And in Verhoef, there was a tricky clause in individual employment contracts binding the employer, the transferor, but then also the transferee, to future collective agreements concluded at branch level. So there was a dynamic incorporation clause. It's a bit technical, but the point was that the court had the feeling that this went too far, that it was not serious to force a transferee taking over the old company to bind that transferee to collective agreements which did not exist at the time of the transfer, excuse me, and which would be concluded only after the transfer had taken place. And the argument which the court used, though not convincing, was freedom of association. The idea was that a pressure would then be exercised against that transferee, new company, to become member of that employer association, concluding those future collective agreements. It's a judgment which is not entirely convincing, because a confusion is created between an obligation to become member of an employers association on one hand, and an obligation to apply the collective agreements concluded by that employer association. And it's even less convincing because the Court of Justice of the European Union refers to another judgment dealing with freedom of association adopted by the Strasbourg Court, okay, Court on Human Rights, which in fact says the very opposite, says that there is no connection between an obligation to apply collective agreements on the one hand and a situation where you would be forced to become a member of an employers association. In fact, in Gustafsson, the Strasbourg Court said the opposite. It is not because you have to apply a collective agreement concluded by an employers association to which you're not affiliated that you are therefore restricted in your freedom of association. The question which might be is whether there was at the time, prior to the Charter of Fundamental Rights of the European Union, such a general principle, the freedom of association, could be answered positively on the basis of an old opinion of an Advocate General in the Albany case. Now, we continue, and I want to deal not with primary EU law or constitutional case law of the Court of Justice, but I want to speak about some interesting restrictions of the freedom of association, restrictions which I think are legitimate, but which I should recognize as restrictions. I should mention them, and they are resulting from regulations and directives. And a very old restriction dating back to 1968 is indeed enshrined in this regulation dealing with free movement of workers. Movement of workers means that it does not mean that we have one European labor market. We have, in fact, as many labor markets as we have nation states, but there are no boundaries between these 27 employment markets. It is free for every citizen of the European Union to go from one country to another in order to look for another job. There is free movement. Sooner or later, you will be pushed back when you don't find the job, but that's another issue. But the point is that in Article 8 of this old regulation, there was the idea that this migrant worker, from the European Union, moving from one country to another, should have the same access, to a trade union, should enjoy the freedom of association on a foot of equality, irrespective of his nationality, as the ordinary workers in the country where this migrant worker of the EU is going to. That is what we can find in Article 8, a kind of, not a recognition of the freedom of association, but the recognition of the freedom of association in combination with equality. Now, why do I think it is a restriction? Because we could also see this as a promotion of freedom of association. It is a restriction because it restricts the right of the trade union concerned, freedom of the trade union concerned to refuse people. And that is an essential element of the autonomy of the trade union. So if you restrict that, you also restrict the freedom of association. Because the principle is indeed that there is no right to association. There's a freedom of association. Now, once upon a time, there was a judgment in 1991, and this is known under the word Asti. Now, Asti is the name of a very bad Italian wine, which I absolutely do not recommend, but it's also the name of an association in Luxembourg which defended the right of migrant workers. Now, in Luxembourg, it's a very small country, you have trade unions, obviously, and you also have chambers. And these chambers, they are instituted by law. And if you're a worker, you need to be a member of the chamber, and you need to pay a tax, a kind of a contribution, which is deduced directly from your wages. And if you indeed do so, you can be elected in the bodies, in the governance of these chambers. You have chambers for enterprises, you have chambers workers. This, of course, to some extent mirrors it's a corporatist system, which has also existed in Italy. And in fact, the word which is used in the judgment is guilds, which means corporations, and the laws applicable date back to the 20s. Okay. Now, this amounted to a situation where these migrant workers, they had to pay a tax, okay? But they were not allowed to the same rights as members of this corporation, because they were not considered to be fully fledged members. And of course, Asti, who was representing these migrant workers, who had to defend their rights, was also forced to deduce wages from their own workers, some of which were migrants, in order, it's complicated, to compete, or not to compete, but to respect the Luxembourgish law. They thought that this was a disgrace and that this was contrary to the spirit of Article 8, because they felt that there was no equality in the field of the freedom of association, because Luxembourgish workers could fully participate, vote, and be elected in the governance of the guild, corporations, and the foreign workers from the EU, while they were confronted with this tax, but they did not have the same rights. Now, this is a very interesting case. And my first gut feeling would be to say, well, I'm sorry, but such a chamber is not a trade union. It's not even an association, and therefore freedom of association, the right to organize, does not come into play. And I say this on the basis of the case law of the Strasbourg Court of Human Rights, which has stated in the past that an association is something which is created by the individuals, by the citizens. It is not something instituted by law. And because it is not an association, the obligation to be affiliated is not a violation of the association, etc. However, the Court of Justice in Asti said, we will develop a notion of a trade union which is autonomous, which needs to be understood and defined according to EU law, and it's not relevant that such an association, that such a chamber is not an association according to Luxembourgish law, and I would add, according to the European Convention of Human Rights. We stick to our own interpretation, and in fact, Luxembourg, you could say, was forced to change its legislation. Okay? It was a preliminary reference, by the way. And then we have a lot of directives in the field of non-discrimination. And non-discrimination is, in essence, labor law, because a lot of these directives are primarily or exclusively restricted to the field of labor law. And now it's very interesting that this field of labor law is defined in those directives. We have, in a way, definitions of labor law in EU directives, in these non-directives. And astonishingly, an issue of labor law, an issue of the field of occupation, is membership of a trade union. And therefore, trade unions cannot refuse people, workers, on the basis of, name it, their their sex, on the basis of their race, on the basis of age, sexual orientation, handicap, and so on the basis of those limitative list of forbidden discrimination grounds. That's a serious limitation of their internal autonomy, which I salute, which I think is correct, legitimate. Furthermore, trade unions cannot, and employers, employers cannot conclude collective agreements which contain provisions which are discriminatory on the basis of what I have just been listing: sex, race, sexual orientation, religion, belief, age, handicap. Okay, and that's fine. That is fine. It pleases me. But there is one major problem. Can we accept in 2023 that trade unions cannot discriminate? It's a political question. Cannot discriminate, but that they are not protected against discrimination, or specifically that their members are not protected against discrimination based upon their trade union affiliation. Because the most common case of non-discrimination in the field of trade unions is, of course, a situation where a worker not recruited because he's a member of a trade union, or is fired because he is a member of a trade union, etc. Now, we should be honest, and we should also say that in these directives, a positive role for trade unions is given in the field of social dialogue in order to promote, to foster equal treatment. But the question is, do EU directives protect workers against intimidation because of the fact that they are a member of a trade union? I would be inclined to say no, they don't. Things have changed a little bit. We have now this very interesting directive recently adopted on adequate minimum wages in the European Union. And it's a directive which is already under attack due to a procedure before the Court of Justice, because this directive in essence deals with wages. And I already explained to you that wages are excluded from EU competences. But there is more to it. Are excluded from EU competences also, is excluded from EU competences also the issue of the freedom of association. And this directive provides two provisions which protect, finally, I would say, finally, the trade union, and which protect trade union members from discriminatory acts. And indeed, the most obvious action against discrimination is the protection of workers involved in the negotiation of collective agreements against acts of intimidation stemming from their employer. Now, this is obviously a kind of protection which is extremely relevant if you're dealing with company agreements, but which is less relevant if you're dealing with collective agreements at sectoral and branch level, because these usually these agreements are concluded and negotiated by staff members of the trade union themselves, and there the trade union would be the employer and not the other part of the bargaining table. And then there is also another little provision in this directive, which tries to protect therefore trade unions against acts of interference of the counterpart of the employer or the employer's associations. These two provisions mirror two provisions of the most fundamental ILO conventions in the field of the right to organize, Conventions 87 and Convention 98. Now, I want to put it very clear that these rules are only relevant insofar as a state decides to have a system ensuring adequate minimum wages by means of collective bargaining. The state has an alternative and can also adopt and ensure adequate minimum wages by means of a statutory or regulatory intervention, not by means of collective agreement. In Italy, I would say that wages, minimum wages, are being set by collective agreements. So I think that these provisions definitely are relevant for Italy, but Italy has already a good system of protection against discrimination. And unfortunately, and this is a point of critique, these provisions which deal with discrimination are not as powerful, not as fleshed out, not as precise and clear as the provisions in the field of non-discrimination in those other core directives with sex, dealing with race, and dealing with the other discrimination grounds. Okay. And then I jump to something particular, and that is something which is hardly discussed. A special species of EU labor law, that is the labor law applicable to the civil servants working for the EU in all these EU institutions. Now, it's important to know that EU labor law, in the classical meaning of the word, okay, one which is studied, is not applicable to these people. All the directives which you have been countering, studying, are addressed to member states, and hence, a contrario, they are not applicable to the EU institutions themselves. And this creates an uncomfortable situation because there is no such thing as patere lechem quem ipse fecisti. It means, it's a Latin word, it means expression. The EU imposes laws on member states, but is technically not obliged to follow these same laws. How are these employment relations regulated? Well, they are regulated by unilateral staff rules, which are adopted by the Council, okay, of the European Union. This means that working conditions of these EU civil servants, including adequate minimum wages, are not set by means of collective bargaining. There is not really a system of collective bargaining taking place. The only thing what might exist is work arrangement. Working conditions are set unilaterally by the EU. And in this process, sometimes a staff committee, a kind of works council, is being consulted. Okay, just consulted. Now, it's important to know that there is a difference between EU collective labor law and industrial relations. It is not because some things, some practices are not regulated, are not recognized, that they don't happen. And this means that it's not because the right to strike in these staff rules is not regulated that strikes don't happen. Of course, strikes happen. And the EU institutions have learned to accept that there were trade unions and that their civil servants were unionized, and therefore they have made agreements. They have concluded agreements with these trade unions, but these agreements, collective agreements, never deal with the working conditions of the civil servants, never deal with minimum wages. They are more about the role of these trade unions in this architecture of industrial relations within the EU institutions. And the funny thing is that in some of these collective agreements, for these reasons, the issue of strike pops up. Okay? There is an attempt to regulate the conduct of trade unions in respect of strikes. But the word strike is a taboo in the EU institutions. The word strike cannot be used. What can be used are what I would call descriptions, definitions of a strike, like a collective work stoppage. So you will find rules in a scenario of a collective work stoppage, because it's impossible for the EU institutions to pronounce this ugly word strike. Why is it impossible? Because we are dealing here with a civil service. And there is still one country in the European Union which in a very radical way prohibits genuine civil servants, it's a small group, but okay, to have recourse to strike. And this is a country which is not without influence in the European Union. It's the German state. That's why this word strike cannot be used. Okay. But you have some rules regarding the right to strike of a procedural nature. Okay. Now, there is one case which is particularly interesting, particularly funny, and that is the case Aquino. It does not refer to Tommaso, to the medieval philosopher, but this refers to an interpreter who was working for the European Parliament. Okay? And because once upon a time, it's a recent judgment of 1 or 2 years ago, there was a strike being announced affecting the European Parliament, because the people doing the interpretation, simultaneous interpretation, well, they disagree with obviously unilateral modification of the working conditions, because they don't collective agreements on that, and they decided to go on strike. So strike was notified. And then the European Parliament decided to requisition interpreters. They said, at least for our some of our parliamentary assemblies, meetings, we definitely need interpreters, and we will requisition a number of them. If not, we cannot function. And that's interesting. That's interesting because in the meantime, the right to strike, just as the freedom of association, just as the right to collective bargaining, has indeed been recognized in the Charter of Fundamental Rights of the European Union, 2009. Now, this charter is a strange charter. It does not work like the European Convention on Human Rights. It's not there to restrict member states and to force member states to respect fundamental rights. It's there to protect you as citizens against the Leviathan, against the EU institutions, especially when these EU institutions restrict your, in caso, right to strike. Now, a normal worker in the private sector couldn't care less because EU institutions will not directly restrict his right to strike. So the workers, which more than any other worker will be safe, will be protected by the Charter of Fundamental Rights, are the workers of the EU institutions, because this EU Charter is applicable to EU institutions and not to member states, let alone to employers, private employers in the member states, except in a situation where the member states is applying implemented EU law. Okay. So this means that these individual workers would say, our right to strike is being restricted in a way which is not in conformity with the Charter of Fundamental Rights. Sure, the right to strike is not absolute, but in the Charter, it is provided under which conditions the right to strike can be restricted. And one of these conditions is that such restrictions should be prescribed by law. And that's the point. There was no provision, there was no legal rule empowering the Parliament, empowering the EU institution to requisition its employees. There was no rule on a kind of essential service. Okay? And of course, Parliament was in big panic. And Parliament tried to say, yes, but we do have a little rule in the staff regulation, which says that the EU civil servants working for Parliament need to be available at all times. Well, but that's a bit strange rule to start with, and it cannot mean that, well, you cannot go on strike. It cannot mean that you don't have a right to work, to breaks, to holiday or whatsoever. So this was entirely lacking the kind of precision and the kind of clarity which was needed in order to justify, from a formal perspective, such a restriction. And the court decided to annul that decision of the European Parliament. It was so a procedure seeking to obtain an annulment, decided to annul that decision of the European Parliament to requisition these people. Now, of course, the bottom line still is, what about collective bargaining? Can we accept that members of EU institutions do not have a system of collective bargaining? Because there is the right to collective bargaining in the EU Charter. I think this is a more fundamental principle. This question stays open. You can imagine that the court, not the court, but the institutions would decide to have such a system of allowing requisitioning of interpreters, but even then, such a restriction should be justified by the aims which are enumerated in the Charter of Fundamental Rights. And I don't see that the functioning or the non-functioning of the European Parliament raises a problem of health and safety and public order, not by definition. You could say it interferes with the rights and freedoms of others if you would include there some political rights of EU citizens. I did not spoke about the previous case because I will have some time to answer questions, but there was a previous case on the right to strike. That was the Acton case, which is a crazy case, where the court just said, it was the Tribunal de la Fonction Publique, so it was a kind of a court dealing with the public service of the European institutions, court which does not exist anymore, and which was a kind of labor court, within the system of the Court of Justice. And this interesting case, the court said that if you go on strike, you are not entitled to have a remuneration. And it said that is a principle of EU labor law. If you go on strike, you cannot ask to be paid. You cannot have the cake and the price of the cake, we say in French. Well, we say it about butter, but it boils down to the same thing. And why did this question emerge? This question emerged because in the system of the EU civil service, there was this rule: if you did not pop up, you were absent in a way which could not be justified, that this would automatically be considered as a kind of a holiday you took, okay, from the limitative amount of holidays you could take, okay. But this meant, of course, that you were paid, and this, the court said, was not acceptable. If you were not present for reasons of strike, you could not have a system where this would be assimilated to a holiday. That's all. This was definitely not a recognition on the rights of the right to strike at the time, but that recognition is now there, thanks to the Aquino case. So I still have 5 minutes, so I beg you to ask me at least one intelligent question or another, and you can do so by asking a question in the conversation or just by taking the floor. The floor is yours. So don't ask me.
Okay.
Grazie. Please do.
No. I'm Alberto. Yes, please, just to support your prayer for a discussion. Please, if there are any questions or even remarks or comments on the presentation made by Philip, please, it's now the time. So if there are any intervention, please, they are absolutely welcome.
Matilde has a question.
Yes, please, Matilde.
Good afternoon. Sorry, I can't switch on my camera because of my bad connection, internet connection. I think because of the weather, but so I would like to thank the professor for the lecture. It was very clear. Thank you. So I don't really have a technical question, just like I would like to know your opinion because yeah, as I understood, if I didn't misunderstood, I misunderstand you, like the Court of Justice had like a negative attitude in this field, like in its decisions, because for example, I was thinking about anti-discrimination law as a good tool to help these people, but if I understood you, this could be helpful only with individuals, not with the trade unions as organizations. So anti-discrimination law like help individuals and not these organizations, these trade unions. So are you optimistic about the use of anti-discrimination law in the future to help trade unions, or in general, how do you think we can overcome this situation at the level of the Court of Justice? So
no, thank you very much. Your question is important. So I wanted to say that the restrictions, okay, which trade unions have to cope with, the restrictions of their internal autonomy, they are primarily based upon directives, okay? Directives which indeed, or regulations which prevent them from refusing people on a discriminatory ground. And I absolutely salute the fact that their freedom is restricted. Okay?
okay.
But I just wanted to say that we should analyze it technically from a positivistic perspective as a restriction, but a justified one, of the internal autonomy of trade unions. And that's why I felt obliged to address it. It was not meant as a critique. Although I must say that the critique, I made some critique on the Asti judgment. Okay, I agree. I was a bit critical about it, but for purely technical reasons. Because my point was that a corporation is not an association, okay, and it's not a trade union. But we could argue that by that a law which prohibits non-Luxembourgish people or even non-EU citizens to participate to social elections, whether it be for a works council or for a chamber, is also a restriction of the trade union freedom, because trade union freedom, there is also the right of a trade union to put everyone on the list for elections. I'm saying this because once upon a time, we also had a discussion about Austria, not Luxembourg. In Austria, in order to be a member of a works council, and therefore in order to be put on a list of the trade union, a list which is submitted within the framework of social elections, you needed to be an EU citizen, not just a worker of the enterprise. And this system was challenged before the Strasbourg court, the Strasbourg court said, well, this is a works council, this is not an association, this is not freedom of association. But the European Committee of Social Rights, which monitors the European Social Charter, not a treaty, said, no, this is, and I think this was brilliant, this is a restriction of the autonomy of the trade union, because due to the system, even if a works council is not a trade union, due to the system, this trade union cannot submit the lists for election it wants to submit. So I have no huge problem with the case law of the Court of Justice in this specific field. My problems are more in the field of discrimination based upon religion or belief, but this is a completely different story, which I cannot develop now. Okay?
Okay, thank you very much.
Thank you for this question. I can, of course,
Okay.
I
Any
will
other
send
question?
documents. I will send documents, Alberto.
Yes, please. Yes,
Yeah.
yes, please. I will upload the documents on our virtual repository. So if you send to me now, we will organize, and then I will upload these files on Virtuale, in which the students will find also the recording of your lesson today. So please, to everyone, have a look to our repository. Okay, so if there aren't any other question, we can end this session. I'd like only to give you quite a sad information. I have learned now reading the homepage of our university. Also for tomorrow, there will be a suspension of in-person classes. So even tomorrow, we have to go on in this way with these online classes. So please, to everybody, stay tuned also tomorrow, of course, with the same channel. So on the same link we have used this afternoon. Of course, everybody is invited to participate to the next lesson of Prof. Dorsmon tomorrow at 9 a.m. and then in the afternoon at 3 p.m. Okay, so thank you very much to everybody, and see you tomorrow then.
It's not a problem, Alberto. They have very good coffee here.
Fine. Thank you. And of course, thank you to Professor Dorsmond also for the quoting of our handbook. Okay. It was not forced. The quoting of Philip,
Spontaneous.
it was not forced by me. It is a free initiative of Philip. Okay, thank you. Bye-bye to everybody.
Ciao, ciao.
Ciao.